Good afternoon. Thank you for joining our webinar today on the new 2022 Employment Law Update. Before we get started, I just wanted to cover a couple of housekeeping items in the Zoom webinar room. A couple new features. One, we have enabled closed captioning. If you wish to turn that off on your end, in the bottom of your menu button, there's a CC transcript button, and you are able to hide that on your end if it tends to be distracting. The other thing to note, we are in a webinar format, therefore all cameras and microphones are muted on the attendees end. Should you have any questions for our presenters, please use the Q&A feature. That'll bump that out to them. And then if you have any technical issues, please use the chat feature. I'm happy to respond. We also have Belena here in the room as well, and she'll help you out with those. We will be distributing a copy of the recording, a copy of the PowerPoint, and an MCLE certificate by the end of the week. And so please anticipate that in your email inbox. Other than that, I would like to mute myself and pass this on to Arlene Yang.
Great. Thank you, Stephanie. Hi, everyone. Happy New Year. It's really a very interesting time being an employment lawyer right now. We've seen Omicron and COVID come back with a vengeance, and we've also seen a number of federal, state, and local agencies that are coming out with new rules and regulations to deal with COVID-19. So we're going to do a quick employment law update, but also we're going to be spending a lot of time on COVID-19 because there have just been so many changes over the last several weeks. So we have, my name is Arlene Yang. I am a principal at Myers-Nave based in the San Diego office, and I focus on giving advice and counsel to employers, conducting internal investigations, and defending employers in litigation. We have offices all around the state, and my practice is all around the state. I have with us today two fabulous attorneys from our office. First, David Middleton.
Good afternoon. Thank you, Arlene. Yes, I'm David Middleton. I'm an associate attorney here in the San Diego office. My practice mainly consists of litigation, workplace investigations, and some advice and counsel to our labor and employment clients around the state. And I'll pass it off to Angelica to introduce herself.
Hi, everyone. Thanks for joining us. My name is Angelica Pivenito. I'm also an associate attorney with Myers-Nave. I'm based out of the Oakland office, but I also do work with our clients throughout the state. My practice, similar to David, focuses on advice and counsel to both our public and private clients, workplace investigations, and litigation.
Great. And thank you, Angelica. And now we're going to because we are lawyers, if we go to the next slide, this is just a reminder that we're just providing some legal information. We're not providing particular legal advice about your own particular situation. So we encourage you to seek counsel for that. Also, just to be aware, we are on January 11th, 2022. Things are changing very rapidly. It seemed when we were just getting onto this call, David said, I had to go check some websites to make sure nothing's changed in the last 2 hours, because that's what it's been like preparing for this, because things are changing very fast. So we're giving you the information that we have right now, but be advised that things may be changing over the next days and weeks. We can go to the next slide, please. We're going to focus today on, some of the general areas that we're seeing where there's some changes in employment law. We're going to focus a large part of our talk today on COVID-19 and health and safety issues. We're also going to talk a little bit about discrimination and equity issues, looking at compensation and wage and hour issues that are stymieing employers, and then a little bit related to leaves, benefits, and accommodations. So we have time for questions in this, so feel free to throw any questions you have into the Q&A, and we'll try to either address them during the presentation at the end, or we can follow up with you afterwards. So just turning to if we can go to the next slide, when we talk about COVID-19 health and safety, this is just a really interesting time. It feels a little bit like it did early in the pandemic, when there were just daily changes happening into what the guidance was from our government agencies. Right now, the New York Times reports that the confirmed virus cases have shot up nearly 600% in the last 2 weeks in California. And daily hospitalizations in California were over 11,800 related to COVID. And state models forecast that the peak could be 30,000 hospitalizations around the end of January. So we're not quite there at the peak yet. There's still going to be more, this is going to be continuing for a little while. On top of this, then, a lot of businesses are facing tremendous staffing shortages. It's not just the airlines, but restaurants and so many different businesses are facing figuring out what to do when so many of their employees are getting sick at the same time. So with that in mind, I wanted to turn to David, who's going to talk about some of the new developments.
Thank you, Arlene. As Arlene articulated, here in California, we're actually above 6 million confirmed cases of COVID, with the average daily rate of about 52,000 cases being confirmed per day. Cal OSHA promulgated and revised and adopted new standards for the second time on December 16th. And with that came added responsibilities on the employer and re-emphasis of its November standards. These emergency temporary standards go into effect this Friday. So it will be prudent for you as an employer to make sure that your policies are in place, as we will discuss. Next slide, please. So the big question is, what are the big changes? Employers are now required to make COVID-19 testing available at no cost during paid time to its employees, even those employees who are deemed fully vaccinated after a close contact with a COVID-19 case, even if they're asymptomatic. Under the emergency temporary standards, what is a COVID-19 test has been refined, and Cal OSHA has provided specific instructions. Notably, employers or telehealth professionals need to observe the test results of employees. So no longer is it the case where your employee could take a self-test at home and then self-report. You need to put protocols in place in order to record and retain the results of those COVID-19 tests. There are additional testing requirements for outbreaks or major outbreaks that occur in the work site or employment arena. And so, like I mentioned earlier, if there are three or more confirmed cases within 14 days, there's going to be a weekly testing requirement. And if there is a major outbreak, there's going to be multiple tests that need to be provided to your employees each week. So where can I find a test? I know there's been recent stories out that there's not really testing to be found. The California Department of Health, Public Health, and the Association of County and City Health Officials have put on their websites places where you can get testing, local testing sites. On January 8th, 2022, Governor Newsom unveiled a $2.7 billion COVID response package, half of which is going to go and is appropriated for bolstering our testing capacity here in California to accelerate vaccinations and expand the hours in which testing sites can stay open. Also, a part of that package is to distribute COVID-19 antigen tests to local health departments. What has not changed under the ETS? Next slide.
We do have a question about whether the ETS applies to any size employer.
Yes, so Cal OSHA's ETS rules apply to generally applies to mostly all California employers, large and small. But one thing that has not changed about the ETS and has been re-emphasized is that employers will continue to have to notify employees, employee representatives, and individuals at their work site of a possible COVID-19 exposure within 1 day. So how do you provide that notification? You can do so in the same manner in which you communicate with your employees normally. That could take that can take place as a personal service or an email or even a text message. But the ETS defines that you need to lay out your disinfecting plan within that communication. A recommendation of ours is that you implement daily surveys of those who come into your workplace, names, contact information, whether that person is experiencing COVID-19 symptoms, whether they think they've come into contact with someone who has been suffering from COVID symptoms. Just in case someone does test positive, you'll have a record of who's been on your site, what day, and do they fall within the high exposure period. Next slide. Another re-emphasis in the ETS, actually the ETS re-emphasizes the California Department of Public Health's recent indoor masking mandate. The ETS actually lays out that those who are exempted from wearing a mask due to health or health conditions or disabilities or any other non-restrictive alternatives, they have to maintain social distancing and they must be tested each week. But as I mentioned, the ETS does re-emphasize that employers should be making sure that their employees are wearing masks indoors properly, and employers do have a breadth of disciplinary action they could take if employees do not want to comply. Next slide, please. Another big question surrounding the ETS are return to work policies. On January 6th, 2022, Cal OSHA updated its ETS to incorporate the California Department of Public Health guidance on isolation and quarantine. That guidance is taken from the CDC in that there is a isolation period of 5 days up to 10 days, depending on testing and vaccination status of the COVID-19 case or exposed employee. Now, the return to work criteria also keeps in mind workplace settings under which asymptomatic employees who are vaccinated, booster eligible, but not yet boosted, they won't have to stay home. However, they will need to provide negative COVID tests within 3 to 5 days after their last exposure. They must maintain the masking policy and wear a mask for at least 10 days, and that employee must continue to not show symptoms. If an employee is showing symptoms, they need to go home immediately and provide testing. If an employee is sent home, you could put protocols in place to help them self-monitor at home, having a written policy saying that an employee should check their temperature twice a day or things like that, monitor their symptoms each day. In order for you to have a record of that, those are the types of policies you can implement to get as much information from your employees as possible. Now, there's a big concern about whether the California ETS or the California Department of Public Health recommendations conflict with local health jurisdictions. Remember that to the extent any of these ETS standards conflict with your local health jurisdiction, the California Department of Public Health has issued and shown guidance that the local health jurisdiction will rule. I know some of you remember when the indoor masking mandate was first implemented in December, the California Department of Public Health came out with clarification that to the extent a local health jurisdiction already had a masking requirement in place, that local health jurisdiction's policy would govern. Next slide. So there are a lot of things that are covered in the ETS. I've only covered a few, but our recommendation is that you review your COVID-19 prevention plans to ensure that you're in compliance with all the emergency temporary standards as revised, both private, if you're a private employer or a public employer. Next slide, please.
We've got quite a few comments as predicted. questions. So I wanted to see if, David, you could answer some of them. We have a number of questions about what it means to if the employer has to provide free testing. Is it like if a county is providing free testing, is that good enough? If you, can you just pay for someone to go to a testing site rather than providing them with a test?
So the explicit instruction is that the employer needs to provide testing at no cost to the employee. So to the extent the employee incurs any cost, the employer needs to make sure that the reimburser covered. I can delve further in if you have a specific question. I would love to answer afterwards, but you should operate under the general assumption that your employee should not come out of pocket for any of the testing that they will have to undergo.
Right, and I guess there's also some concern raised about because of so many people taking tests right now, there can be a lag in the time it takes between you taking the test and getting the results. Would an employer observed rapid test be adequate?
So the California Department of Public Health guidance on that says that we need that the isolation period can end after 5 days if the symptoms are not present and a COVID-19 negative test is collected on or after the 5 days. So that negative test needs to be collected. So if there is a lag you've not collected that test, that isolation period needs to be extended, and isolation would be extended up to 10 days if you have not received the test. After 10 days, the person should be able to return to work, assuming that there are no symptoms present.
And if you can ask your questions in the Q&A, that'll help us to track it better. We also had some questions about the isolation period. Can employers have a longer isolation period than is the minimum required in the ETS?
Yes, the employer is free to have a longer, to protect its employees as it sees fit. They're the closest to that employee population, so there's no prohibition saying that you can't have a isolation period that exceeds the guidance by the California Department of Public Health.
Okay. And then there are also questions about whether employees need to be paid during the isolation period.
So the guidance does say that the ETS does say that employers need to pay for the testing during paid time. So yes, you will need to compensate the employee for that time it takes to go get the test.
And I think also the question might be related to whether someone has to be paid during their isolation period. And that may depend on if they developed COVID through the workplace, then there would be the exclusion period must be paid. And then there may be, sick leave involved. We'll talk about that a little bit more. Angelica has some more updates on sick leave. We also have a number of questions about vaccination, but that's coming up a little bit later in the presentation.
Yeah, I know there's a lot of questions that center around COVID, so we appreciate your interest and we'll try to get as many questions answered as possible. So I wanted to touch on before I pass it over to Angelica about the new temporary indoor mask mandate. It started on December 13th. The California Department of Public Health issued that guidance, and then on January 5th, it was extended until February 15th. I want you all to keep in mind, to the extent you do have operations in specific locations that have stricter masking policies than what has been promulgated by the Department of Public Health, you need to follow the local guidelines. For example, Los Angeles County's Department of Public Health already has a mask mandate, but they're strengthening that guideline to say that employers are required to make sure those face coverings are N95 or KN95 grade. So to the extent that the local health guidance is stricter than the Department of Health guidance, we recommend that you follow the local health guidance. The California Department of Public Health's history has already shown that the local health jurisdictions will govern in those type of situations. So the takeaway in the mask mandate is to modify your policies to require that masking is worn in the workplace to protect your employees. Follow the local jurisdictions, especially if they have more protective rules. And this applies to all of our employers, both public and private. So I'll try to look through the questions, and if they touch on what I'm doing, we can answer at the end. But right now I'm going to pass it to Angelica to talk about the federal OSHA emergency temporary standards.
Thank you, David. If you can go to the next slide. Okay, so I'm going to speak a little bit about the federal OSHA's emergency temporary standards, and a piece of this includes vaccine mandates. So just generally first, the federal government issued a number of orders to minimize the risk of COVID-19 transmission in the workplace, including certain vaccination requirements. So we like to think of this as being in 4 different buckets, but perhaps the most pertinent bucket here would be the one for the private employers with 100 or more employees. So with respect to that vaccine mandate, the federal OSHA is currently in the comment period, which means it is not currently in effect. On January 7th of this year, the Supreme Court was scheduled to hear oral arguments on the validity of this vaccine mandate. And if the Supreme Court decides that the vaccine mandate may go forward, a final rule on this is due on January 19th of this year. But because California is on what we call a state plan, California has a different set of emergency temporary standards under Cal OSHA. So what does that mean? So that means within 30 days, California will have to adopt a plan that meets the minimum requirements of the federal plan and closely aligns with it. So that would make the due date in California February 18th of this year. So back to the kind of the different buckets of federal mandates. There's also a vaccine mandate for healthcare workers, and then also as well as federal contractors and subcontractors and federal employees. So as to the vaccine mandate for federal contractors and subcontractors, that as of December 7th of 2021 has currently been stopped by a nationwide preliminary injunction. So we recommend that you consult with counsel on the latest updates as to that. And that would apply to any federal contractor or subcontractor employees that are working in connection with a federal contract. And then for federal employees, that's currently in litigation and required that all federal employees be fully vaccinated by November 22nd of last year. If we can go on to the next slide. So some employer takeaways are essentially to keep apprised of the latest updates to the vaccine mandate issue, especially for employers with 100 or more employees. And then, consider developing policies now and gathering vaccine information for employees to ensure that your workplace meets compliance with the pending due dates. And then I also wanted to mention that in California, public employers with 100 or more employees will also likely be covered by this vaccine or testing mandate. And that's because under California's state plan, that federal OSHA requirement will also apply to public employers with 100 or more employees. And if we can go on to the next one. And I'm going to pass this over to Arlene to talk about employer vaccination policies.
So we know that many employers, even though these vaccine mandates are not yet always required for all types of private and public employers, we do know that many employers have been imposing their own vaccine mandates or vaccine or test mandates. And so based on the science and where the public health agencies are going, some of these policies say you must be fully vaccinated to enter the workplace. We're recommending that employers think about trying to update their policies and revising what it means to be fully vaccinated. The evidence has shown that people who are boosted, if they're eligible for boosting, have quite a much lower rate of hospitalization if they do get infected. And so to protect employees and the people they may come in contact with, it may be time to change the definition of fully vaccinated to be require boosters as well. We see just today, I saw a statement from the CEO of United Airlines. They were the first airline to require their employees to be vaccinated. And they said that they currently have 3,000 employees who are positive. And that's a huge number, but they said that not one of their vaccinated employees is hospitalized. And before this vaccine mandate, they were having on average one employee dying a week because of due to COVID, and that they haven't had any deaths in the last 8 weeks. So these policies do make a difference and do save lives of employees. So that's just something to consider as you're going forward. And next, we're going to turn.
Go
ahead.
I wanted to jump in. I saw a question about whether an employer has to apply disciplinary measures if some employees are not complying with the vaccination policy, or is it at the employer's discretion? Just wanted to be clear that the Cal-OSHA ETS right now does not mandate any vaccination right now, but if you as an employer have a vaccination policy, we recommend that it's written down, and that if you do want to impose any type of discipline, you make that express in the policy that you give to the employees before implementing any discipline, so that employee is on notice that not complying with the vaccination policy would subject them to possible disciplinary action. But employers are given a broad disciplinary action as long as the discipline for someone who may not want to be vaccinated or who is medically exempt from being vaccinated is not predicated on a protected class. So on religion or any type of medical protection that they may have.
Great, and then I guess we'll go on to the next section.
Okay, yeah, so this is, so David just touched on this, so this is great timing. But these are the, I'm going to talk about the exemptions to vaccine mandates. So a lot of employers may have already dealt with this issue if they've imposed a vaccination policy. So under both the federal EEOC standards and the DFEH, that's California standard, there are two categories of these exemptions to the vaccine mandate, which are important if in the future vaccination policies are required or mandated under the emergency temporary standards. So, so those two buckets those two categories are protected under the Americans with Disabilities Act and Title VII of the Civil Rights Act, as well as the state's version of the Fair Employment and Housing Act. And these reasonable accommodations would be based on either disabilities or related medical conditions, or a sincerely held religious belief. And under both the EEOC and the DFEH, employers are prohibited from retaliating against employees for requesting a reasonable accommodation to a vaccination mandate based on either of these two categories. And if we can go on to the next slide. So what we recommend to employers is if they do have a vaccination policy in place currently or plan to have one, that in their written policy, they include the process or the procedures for handling any reasonable accommodation request based on either a disability or a sincerely held religious belief. And then we also recommend that you train all personnel who are handling such accommodation requests. So this may be, your HR folks, or another designated person within your organization. And we recommend that because there are a lot of pitfalls in navigating this process, especially because it triggers your duty to engage in the interactive process. And what that essentially means is, sitting down with the employee and speaking to them to find out more information on how the employer can reasonably accommodate their disability or sincerely held religious belief. And these exemptions apply to all employers, public and private. For public employers, we do recommend that you consult your MOU as well. And if we can go on to the next slide, please. Okay, so the next topic is related, and this has to do with counterfeit vaccine cards and falsifying vaccination status. You may have all seen this in the news recently with the NFL and Antonio Brown, who provided a fake vaccination card. So we do want to recommend that all managers be trained on looking for certain signs of counterfeiting, and these include, the absence of key information, including the manufacturer or the appropriate date. If you see, the dates between a first and second dose as like something like 8 weeks or something beyond the CDC's recommendation of that 3-week waiting period, that should also trigger some alarm bells in your head. And then, the cards being printed on flimsy or poorly cut paper, illegible government seals, or cards that appear to be entirely printed with no handwritten information. So we do recommend that you train your managers on identifying these types of false vaccination records. And if we can go on to the next one. And some employer takeaways, like I mentioned, review your policies regarding workplace safety and employee conduct. And we also do recommend that as you're collecting these vaccination records, that you include some sort of certification or attestation to your policies that essentially would work to avoid employees from producing false vaccination records, and also making it clear that if they do produce false vaccination records, that they could be subject to disciplinary action up to and including termination. And that's, to reinforce the consequences for falsifying health records and basically putting employees on notice that they can be disciplined for such conduct. And if we can go on to the next one. Okay, so I'm going to also be talking about Senate Bill 606, which strengthens Cal OSHA's enforcement authority. And generally speaking, what this law does is it expands Cal OSHA's enforcement powers by creating 2 new categories of violations, an egregious violation and an enterprise-wide violation. And of course, those come with civil penalties that can lead up to the hundreds of thousands of dollars. I think for the enterprise-wide violation, it could be $124,000 fine for each willful violation. So we do want to strongly recommend that employers ensure that their policies and procedures comply with these Cal OSHA standards, and then also review any site-specific workplace safety hazards and communicate with Cal OSHA about, when they make any requests for documents or if they're conducting an inspection, because you do want to avoid these new expanded powers that Cal OSHA does have. They now have the authority to issue subpoenas during an investigation or seek injunctions restraining certain uses. So, as to avoid your business place being shut down for any period by Cal OSHA, we do recommend that you review your policies and be mindful of any requests for information. And that's especially pertinent because Cal OSHA has jurisdiction over almost every employer in California, as David mentioned earlier. And if we can go on to the next one. So we're going to next talk about equity in the workplace, and I'm going to pass this over to Arlene.
Right, thanks, Angelica. So I wanted to just point out, we're going to talk a little bit about some of the discrimination or types of things that we're seeing related to equity in the workplace. And I just wanted to point out that, for many, many years, the bread and butter of employment lawyers was handling discrimination claims, sexual harassment, claims related to failure to reasonably accommodate a disability. And over the last 2 years, we've spent a lot of time thinking about COVID and health and safety, but all those other claims about discrimination, sexual harassment, all that, that's still there, that's still happening. We're doing lots of investigations on those issues all the time. So we're not going to focus on those areas right now because there hasn't been a lot of change in the law, but we did want to point out a few areas that you should be aware that you may not have been thinking about. And so next we're going to go on to David and the ADA.
Like Arlene articulated, thank you, Arlene, that we all have been in a remote space, working from a distance. So we've seen a rise across the country in website accessibility cases under the ADA. A lot of people are accessing or being exposed to your business through your website. So there are standards that should be applied in building your website, making sure it's accessible to everyone. We see these cases come up a lot when someone alleges that a website's not accessible because they don't have a screen reader, or it doesn't provide closed captioning. So when you're building out your websites or you're modifying your websites, you're rebranding and you're going through those processes, our recommendation is that you build out or you ask whomever's helping you to build out some web coding design to make sure your website is accessible to those who are disabled, those who are blind, that may need a screen reader for those who are blind, and provide closed captioning. Here we've actually provided closed captioning in our webinar here to provide services to those who may be hard of hearing. So there are certain standards and guidelines that if you generally follow these web content accessibility guidelines, they've been recognized by the California Attorney General's office, but following these generalized standards will help you. Now we can't guarantee that someone will not bring a claim against you, but it's better to be preventative and understand that these claims are out there. Recently in California, there was a California appellate court decision that actually went into the employer's favor, saying that some of these serial plaintiffs that go to these websites without a genuine intent or a bona fide intent to use the services can't prove a claim for website accessibility to show a bona fide intent. But oftentimes it's more costly to get a case through litigation and up to appellate court to say someone didn't have a bona fide intent to use the services. It's a lot more expensive than just making sure the website is accessible to everybody from the outset. So next slide.
Yeah, I just wanted to point out, so, in the past, there were these serial plaintiffs who went around to see if the curb wasn't correct and following all the physical barriers. But especially we've seen in the last few years with the rise of COVID, they found this way to find a claim where they can do it from the comfort of their own home and just look for websites. So, we look at the number of complaints that are filed every day, and a very large number of them are ADA related claims, either in person, in the physical world or on websites. So just be aware that this is growing.
Next slide, please. Another topic that we really want to make sure that employers are aware of is SB 331, the Silence No More Act. I know a lot of you all can remember in 2018 with the passage of SB 820, which really resulted out of the Me Too movement, which prohibited the prevention of disclosure of facts underlying sexual harassment and sexual discrimination cases. That law prevented someone from stopping someone from disclosing that, and SB 331 actually expands on that. And in any settlement agreements, this law is going to prevent an employer or anyone from will prevent employers from preventing someone from disclosing those facts surrounding any claim of workplace discrimination or harassment that's based on any protected class. The bill also prevents employers from mandating that their employees sign a release or a non-disparagement agreement in exchange for a raise or a bonus or any continued employment or condition of employment. Next slide, please. So our recommendation in these types of instances are to update your forms, your settlement agreements, your employment agreements, and think carefully about how to resolve potential or ongoing litigation. Agreements with your employees that are for raises and bonuses and continued employment. You want to make sure that you remove all non-disparagement provisions that restricts the employee's ability to disclose any unlawful acts in the workplace. Or we can also recommend that you can subtract by adding or making sure you put in a provision that states that nothing in your separation agreements would prevent this person from disclosing what they reasonably believe is an unlawful act. So sometimes it's not about doing a full analysis of removing everything, but it may be more cost effective and more timely for you to be able to just add that it's not foreclosing that employee's right to bring something they reasonably believe is unlawful. When you're dealing in a separation agreement space, you also want to inform your employees that they have the right to consult an attorney under this law, and you have to actually provide 5 days for them to do so unless that employee knowingly waives that right to go seek counsel of an attorney. This applies both in the private and in public context. So everyone should take a look at their form documents to make sure that you're in compliance with this law. I think right now we're going to touch on compensation and wage and hours, so I'll give that and throw that back to Arlene.
Right. So another thing that we're still see every day are claims where employers have not complied with California's wage and hour laws. California is it's just incredible how many different rules there are and how difficult it is to comply. And we see the largest companies in our country getting hit with class actions on these issues every day. And so it's very difficult for smaller companies who may not even have a full-time HR person to try to navigate through some of these issues. The issue I wanted to focus on today primarily is our arbitration agreements. So we just saw recently in December, there was a verdict for $155 million against an insurance company after one employee sued. And it was $150 million in punitive damages. That is on the heels. In September, there was another case where it was a lot of publicity against Tesla, $137 million. Again, mostly punitive damages. And so these types of awards are the product of California juries. And that is one of the reasons why we generally recommend that employers consider arbitration agreements, because then the decision is made by an arbitrator rather than some unpredictable juries. So one thing that, and cases can move faster. We've seen, especially during COVID, arbitrators have been able to move to make decisions faster than having it go, jury trials keep starting and stopping. It's taking a long time to get cases through the court. So arbitration may be a faster venue. But at the same time, there is a pressure against arbitrations, especially in California. And several years ago, the California legislature passed this law called AB 51, which, among other things, banned mandatory arbitration agreements in employment. That was immediately, there was an immediate lawsuit, and it's been stayed since then. But in September, we did see a decision from the Ninth Circuit in this U.S. Chamber of Commerce versus Bonta, where they did uphold provisions of the statute that would ban mandatory arbitrations. That decision is actually on hold right now while the full panel of the Ninth Circuit is deciding whether to reconsider the case. But this is a very big issue. We're expecting that there will be some other decisions that will be happening in 2022. So stay tuned. In the meantime, we are still recommending that employers consider mandatory arbitration for their employees. And then, there are other things that we're expecting to see in 2022, and one of them is related to California's Private Attorneys General Act, which is also known as PAGA. It's a representative type action where one employee can be asserting the claims of many other employees, and it could be with most of the penalties actually going to the state. So what's been challenging for employers is that California does permit class action waivers and arbitration agreements. So rather than having a class action, the employees who signed these arbitration agreements would have to bring their claim in arbitration. And that gives less leverage to the plaintiff's lawyers. But PAGA claims cannot be waived like that through an arbitration agreement. Whether that can continue is the issue that is in this Viking River Cruises case, and there are a number of other cases that are all before the Supreme Court. So in December, the Supreme Court said it would hear this case. So we may have a decision as to whether arbitration agreements may prevent employees from bringing PAGA claims. So just, keep an eye on that. That may be something that we'll be seeing in 2022. The Supreme Court has been much more in favor of arbitration than the California state and federal courts. And then the third thing to keep in mind on the next slide is just to be aware about paying arbitration fees. If you do get into arbitration, you will need to pay the fee within 30 days. What had happened was a few years back, there was a lot of publicity because some employers were making people bring their claims in arbitration, but then not paying the arbitrator fees. And it was felt that the employers were kind of dragging their feet and delaying justice here. So there was a statute that said you must pay within 30 days, otherwise you waive the right to arbitration, and there may be other possible sanctions. And now we have SB 762. This is a new statute, and it requires the arbitrator to issue invoices for fees and costs to all parties on the same day. And then the payment should be due on receipt unless there's an express agreement otherwise. So it's just a reminder, if you are involved in arbitration, you have to get moving and pay the arbitration fees right away so that you don't get stuck and caught up by these laws. And then we're going to go on to the minimum wage increase with Angelica. Oh, no. So, okay. Yes, we have. So this is, we're recommending you should include arbitration agreements in your handbook, and then that would be signed by the employee. Every couple of years, we're seeing new cases that are kind of tweaking what you need to have in an arbitration agreement for it to be enforceable. So if you haven't updated in a few years, we encourage you having counsel take a look at it so that you have the best chance of making it enforceable. And and then just be ready for changes in 2022. Thanks.
Okay, so now we're going to talk about the minimum wage increases. So effective January 1st of 2022, the California minimum wage will increase to $14 per hour for small employers, which is defined as 25 or fewer employees. And it will also increase to $15 per hour for large employers, which is defined as 26 or more employees. So all employers should also note that the minimum wage increases also affect the salaries for exempt employees. And that's due to the requirement that exempt employees earn no less than 2 times the state minimum wage. And in the case of small employers, that would mean a minimum salary of $58,240 per year. And then for large employers, the 2 times the minimum wage would be a minimum salary of $62,400 per year. We also want to make employers be mindful of the local minimum wage increases that may be imposed by your city or county. So employers are required to follow the stricter standards. So in the scenario that your local minimum wage is even higher than the California minimum wage, you must follow the local minimum wage. For example, the minimum wage in the city of San Jose is increased to $16.20 per hour for all employees effective January 1st of this year. So we just recommend that employers be aware of that. And if we can go on to the next one. So the employer takeaways, like I said, update your minimum wage payments and postings to reflect the state and local increases. and ensure that all of your exempt salaried employees, including your part-time exempt employees, that they're being paid according to these new minimum salary requirements. And this minimum wage increase applies to both private and public employers. And if we can go on to the next slide. So we're also going to talk about Assembly Bill 1003. So under the old law, an individual will commits to grand theft when they take the money, the labor of another in excess of $950. Assembly Bill 1003 makes the intentional theft of wages, including gratuities, in an amount greater than $950 from any one employee, punishable as grand theft. So that that new law also allows that money to be recovered as restitution. This became effective on January 1st of this year. And for purposes of this law, independent contractors are also included within the meaning of employee. Entities that hire independent contractors should be aware of that. And some of the employer takeaways are that, managers should be aware that they can now be held criminally liable for the theft of wages, and employers should take affirmative steps to ensure wage and hour compliance to avoid the significant penalties imposed by this new law. And AB 1003 applies to both public and private employers. So if we can go on to the next slide. So our last topic is leaves of absence, benefits, and accommodations. So there is just one topic that we wanted to talk about in relation to this, if we can go on to the next slide. So as many of you may recall, Senate Bill 95 went into effect on March 29th of 2021 with retroactive applicability to that year. And SB 95 expanded the requirements for employers to provide supplemental paid sick leave to employees impacted by COVID-19. That law, if you all recall, expired on September 30th of 2021. So that means that there is no requirement for COVID-19 supplemental paid sick leave. However, this past weekend, Governor Gavin Newsom called for a new legislation that would revive supplemental paid sick leave policies as part of this coronavirus response package to the Omicron surge. So that, the governor is pushing for a new supplemental COVID-19 paid sick leave law, given the current situation. And while he did not share details on what that policy or what that new law would entail, we do want to make sure that you're all aware of that may be coming in the upcoming weeks. And then we also recommend that you consult with legal counsel to determine whether there are any local laws that might be applicable that cover COVID paid sick leave. And when I also want to remind everyone that, when it was in effect, SB 95 did apply to both public and private employers. So if a new law is to take effect soon, then that would likely be the same situation. But we do recommend that you consult with your legal counsel with the most up-to-date information. And then if we can go on to the next slide. I'll pass this back to Arlene for questions.
All right, well, thank you. So we do have some time for questions. If you have some more questions, please put them in the Q&A. I guess I did want to point out that even though there isn't this formal COVID paid sick leave, the ETS still does have some requirements. If someone was exposed and developed COVID through the workplace, then there may be a requirement to pay the employee during the exclusion period. So you're going to want to take a look at that. It's been really challenging for us over the last couple of weeks to think about what rules apply. We have the California Department, Occupational Safety and Health Administration, and they're the ones who promulgate this emergency temporary standard related to the workplace. But then we also have the California Department of Public Health, and they're issuing their own guidance that's general. And so sometimes we've had these periods where the two are in conflict, where, for instance, the California Department of Public Health is loosening the standard and the California ETS still has a higher standard. So you have to kind of figure out which one is going to apply to employers. And but what we have been seeing is that after a little while, the agencies will get it together and they'll release new guidance to kind of clarify where it is. So there's a period of confusion where we're trying to guess what is the new standard that applies to employers. And then after a little while, they'll come out with some guidance to clarify what applies. I guess we have a question, is there a state database available for an employer to verify a vaccination record? I think Angelica was looking into that.
So the employer wouldn't be able to verify the employee's vaccination record, like accessing that information, but there is the the state digital smart website where employees could download a digital copy of their vaccination record.
Right. And although, just to be aware, I've had some problems getting my own record, and I've had 3 shots, but it only has record of 2. I can't get it to recognize the 3rd one. So just be aware that it may not always be accurate. Let's see. So we have
that's to the COVID supplemental paid sick leave.
Do you want to repeat the question, Angelica?
Yeah, so someone asked, the new law on paid sick leave for COVID, do you think it will be applied retroactively to help employees who got sick over the holidays? So, if the new law were to apply later on, whether or not it would apply presumably to January 1st of this year. There's no way for us to know that right now for sure, but based on Senate Bill 95 from last year, that was extended retroactively from March 29th to January 1st. So if it is consistent with that older law, then it would likely be extended retroactively to January 1st of this year. Though, like I mentioned before, we don't know for sure yet.
Yeah, we did have another question about isolation periods, and if the employer extends the isolation period beyond what's required by law, whether you should be paying for that. And that, I think that's going to be a matter of the employer preference. And we've seen some employers who they think it's important to provide this kind of sick leave so that the employees are encouraged to stay home when they're sick and not spreading it in the workplace. So that may be the route you want to take. You have to kind of figure out what's right for you. And we're happy to help you work through those issues. So, yeah, let's see if did any of you have anything else you'd like to add before we sign off?
No, I know this is ever changing each day. So we will try to stay on top of it as much as we can and get out the supplemental materials to you all. So thank you for giving us your time over the lunch hour.